speaker, Dr. Bhuban sir, Principal of NF Law College, respected Ms. Rita Verma, Principal in charge of Cochrane Law College, respected Dr. Pranay Kumar Aditya sir, Director IQAC, Cochrane Law College, and respected all the esteemed colleagues and enthusiastic participants of this session. So I, Rita Surgari, Assistant Professor of KLQ, on behalf of the organizing team, welcome each of you in this 5th episode of online lecture series. Now I would like to request our Principal, Madam Ms. Rita Brahma, to give the welcome address for today's session. Over to you, Rita ma'am.
A warm, yes, thank you. So, good morning to one and all present. Respected today's guest speaker, Dr. Bhuban Barooah, Principal NEF Law College. A warm welcome to you, sir. And I extend my gratitude for accepting our invitation within a short period of time to speak on the topic relevancy of administrative law in terms of constitution of in terms with the objectives of the Constitution of India. So a warm welcome to you, sir. I believe that your deliberation on this topic will definitely enlighten the student, and I know that administrative law at present is under the 4th semester. However, I would like to inform the second semester as in the first semester students that the topic that is being really delivered today is of much importance in order for you to relate constitutional law with that of administrative law. So I hope that each of you will be a patient listener and will take away the information that will be shared by today's guest speaker. And I also know that the present 5th or the 6th semester students will also be refreshed whatever they have learned in the previous semester. And I believe today's session will be a very useful for each of us. And a warm welcome to teachers and non-teaching staff of Cochrane Law College, my dear student friends, teachers of other institutions, and participants from other institutions or across everywhere. So a warm welcome to each of you. And I also take the privilege to thank IQAC team of Cochrane Law College for organizing the lecture series in the name of the founder principal, led Niranjan Kumar Narzari sir. So I hope that today's session will be a good one, and with these few words, I thank each of you. A warm welcome to you, Dr. Bhuban Barooah, sir. A warm welcome.
Thank you.
Okay.
Thank you.
Thank you, Rita madam. Thank you. Now I would like to introduce our speaker guest. So it gives me an immense pleasure to introduce today's guest speaker, Dr. Bhuban Barooah, sir. He is the former principal of Tezpur Law College, Tezpur, and previously served at Guwahati Law College and University Law College. At present, he is the principal of NEF Law College, Guwahati. So today we all are delighted to have sir, a great personality with such good experience, to enlighten us on the topic relevancy of administrative law in terms of objective of the Constitution. So we are honored by your presence in today's session, sir. So once again, I extend my warm welcome to you, sir. Now the platform is all yours, sir.
Thank you. Thank you. Thank you very much. So, good morning, everyone. So first of all, let me express one thing very honestly, that what I know, I do not know. What I do not know, I know. So with this little knowledge, I don't know how much I'll be able to satisfy you, as because I am being entrusted to speak about the relevancy of the administrative law in terms of the objectives of our Constitution. So the Constitution, as you know, being the student of law, today I like to address especially to the students, as because basically I'm a teacher. So yesterday I told your principal ma'am that this will not be a lecture; it will be a class type lecture or lecture type class. So the relevancy of the administrative law. What is administrative law? Why it is so important day by day? The importance of the administrative law. It has been growing up. What's the reason behind it? The reason behind that we have the constitution. We have the very good constitution. It is said we have a very good constitution, and to fulfill the hopes, to fulfill the goal of the constitution, to fulfill the hopes and aspiration of the people, so we need the administrative law. If we do not follow the administrative law, then we cannot fulfill the hopes and aspiration of the people. We cannot touch the requirement. We cannot touch the needs of the people, needs of the citizen. And so ultimately we will not be able to uh, fulfill the dream of Mahatma Gandhi to be a Ram Rajya. Ram Rajya in the sense, it is not a religious sense, my dear friends. Ram Rajya is the Ram was a character. The character of the Ram was fully of, he followed the whole principles of administrative law. For the well-being of the people, for the benefit of the people, he did not compromise anything. Even he did not compromise with the interest of his wife. So the Ram Rajya it's a dream of Mahatma Gandhi to be a Ram Rajya, to build a Ram Rajya in India. That means the principles of the administrative law we must follow. Why we should follow? Thing is that our constitution, it is said, somebody wants to say that our constitution is a borrowed constitution. You know that most of the features of our constitution, most of the principles of our constitution, it has been borrowed from other countries. Say, for example, at the very beginning, in the preamble, say republic, the ideals of liberty, equality, and fraternity, uh, uh, it was borrowed from France. So the parliamentary type of government, the rule of law, the prerogative rights, these are all borrowed from UK, British Constitution. Then the fundamental rights, the independence of judiciary, the judicial review, these things, the impeachment of the president and the removal of the Supreme Court and High Court judges, even in the post of the vice president, these are all borrowed from the US, you know. And directive principle of state policy, you know better, that it has been borrowed from Irish Constitution. And from Canadian Constitution, the federation with a strong center, the you know it is now we our Supreme Court says the federalism is a basic feature of the Constitution, and we have a very good relation in between the center and the state, and the so of course there sometimes it seems that sometimes it seems that there's a tug of war in between the power of the center and the power of the state. So the freedom of trade and commerce, it has been borrowed from Australian Constitution, and suspension of the fundamental rights during the emergency, it has been borrowed from Germany Constitution. And fundamental duties and ideals of the justice, social, economic, and political, it has been borrowed from USSR Constitution. At that time, it was known as the USSR. Now it is Russia. And from South African Constitution, procedure for the amendment of the Constitution and election of the member of Rajya Sabha, it was borrowed from South African Constitution. And procedure established by law, you know, the procedure established by law in America, due process of law, this procedure established by law, this concept has been borrowed from Japanese Constitution. So most of the important features of our Constitution was borrowed from different foreign countries. And some critics wants to say that after passing of 70 years of independence, still uh, it is far away to reach the goal of the constitution. Some critics wants to say that our constitution, if our constitution is compared with a cake and it has been borrowed from different foreign ingredients, and that is why we are unable to digest it. It's a very hello, is it okay? Hello. It's a very controversial subject that we may fail the constitution or constitution fails us. It's a very controversial thing. Somebody says that we people are good. Somebody says that we people are not good. We people are not as per the provision of the constitution. We are not fit for that. So we are unable to fulfill the objectives of the constitutional provision. And somebody says that no, constitution is not good as because it was not based on the basic things, the local concepts were ignored at that time. So we are unable to digest it. Whatever. So the now question is that what is the relevancy of administrative law in terms of the objectives of our constitution? You see, the administrative law. Before explaining the thing, go to the subject. I must say that I want to cite one example. That example is that suppose you have one luxury omnibus. You have a very nice, beautiful luxury omnibus, and you want to run in between Cochrane and Guwahati. So you have a luxury omnibus, very beautiful, very costly. So, but the question is, if you the use of the bus, everywhere the administrative law, the rule, everywhere you will find the rule. Even in your family, there are some rules. In each family, they have their own rules. Suppose you have one bike, you are to maintain the bike. So similarly, you have one luxury bus and you want to run in between Guwahati and Cochrane, then how to run the bus? How to run the bus? What is your motive? You must get some profits from bus. So how to run the bus? So you are to appoint the driver, you are to appoint the conductor, you are to appoint the handyman, and you are to appoint some supportive staff. Okay. So how to appoint? How to appoint the driver? There must be some criteria. There must be some principles. A driver without a driving license, you cannot appoint him as a driver. So you have to appoint the drivers, you have to appoint the handyman or other supporting staff according to your needs, according to your objectives. What is your objective? Your objective is to run the bus in between Cochrane and Guwahati. So similarly, we have very good constitution. So since we have a very good constitution, as we have borrowed very good concepts, very good ideals from different foreign countries. So now, how to achieve the goal of the constitution? How to achieve the goal of the constitution? So we have to follow some principles. So these principles, the compilation of these principles, these principles are provided in the administrative law. So, the principle of rule of law, principle of natural justice, the principle of ultra vires, the principle of separation of powers, the principle of judicial review. Apart from all these things, we have some appendix in our administrative law, say PIL, the provision of PIL, the provision of ombudsman, Central Vigilance Tribunal, RTI, then of course the local has not been passed yet. So what is the purpose of the administrative law? What are the basic things of the administrative law? The first thing, you see, we citizens, we have some liberty. We have liberty. And the government officials, they have power. And it's a common phenomena that always there's a tug of war in between the power of your administrative power, administrative officials, and the liberty of the people. So there must be one Lakshman Rekha in between the power of the government and liberty of the people. The power of the government, it should be exercised properly. It shouldn't be arbitrariness. There shouldn't be any room for arbitrariness. As because it is said that power tends to corruption, absolute power tends to absolute corruption. So the power, there shouldn't be any use or misuse of the power. Okay, there should not be any. So to prevent the use and misuse of the administrative power, there should be some mechanism, checking mechanism, check and balance. The principle of check and balance in Indian system, it is said, the court says that check and balance, the check and balance it should be maintained. So the checking of the use and misuse of the administrative power, number one. Number two, the citizen, they must be ensured for what? For impartial determination, of their dispute by the officials. You see, what is the difference between man and animal? Do you know what is the difference between man and animal? The very difference between man and animal is we have the sense of improvement. The animals do not have the sense of improvement. And sometimes it seems that some animals are more disciplined, more rational than us. You see the ants, you see the elephants, you see even in our in Kaziranga, you never find any fight in between rhinoceros and buffalo. Today there's a big fight between rhinoceros and buffalo. Today there's a big fight in between your elephants and other animals. So, but in our society, it becomes very common. So Plato says that man is the savagest animal of the world. They can only be godlike by means of education. So, we have the thing is we have the sense of improvement, and animals do not have the sense of improvement. So since we have the sense of improvement, so sometimes the subject matter is one and parties become more than one. Say 1 plot of land, the subject matter is 1 plot of land, 1 katha plot of land, suppose 1 bigha plot of land, but you are saying that you are the owner of that property. I am also saying that I am also owner of the property. The conflict arises. So when because we have suppose in one side one sweet is there, another side the bitter gourd is there. Which one you will choose? Definitely in one side one mobile is there, and another side one chalk pencil is there. Which one you will choose? Definitely the mobile. See why? As because we have the sense of improvement in every aspect. We have the sense of improvement. Animals do not have the sense of improvement, and that this is the key point of conflicts. So since this is the key point of the conflict, so earlier during the time of the police state, the rulers they accepted it, that it's a legal battle. Somebody may be won, somebody may be defeated. But later on, when it was uh, realized by the rulers that no, the quarrels, the conflicts, it must be resolved amicably. Unless it is not resolved amicably, then it affects the economy of the state, it affects the politics of the states, it affects the society of the state. So, so one mechanism is required. What mechanism? That after emerging the welfare state, one mechanism was evolved. That mechanism is the law. The law is the equipment. The law is the instrument to run the society, to conduct the society. Earlier, the law was made to conduct the society, to control the society. During the time of the police state, the purpose of the rulers was only to fulfill their sweet will. But now, now after emerging the welfare state, what is the purpose of the state? The purpose of the state to fulfill the well-being of the people. So, so so the law must be what is the definition of law? In our constitution, in Article 13, it is said, the Article 12 to 35, these are all provision of fundamental rights. In 13, it is said the rules, regulations, bylaws, all these things are made by the central government or by the state government, as because the legislature can make the law. Of course, they have some limitation, but the thing is that law cannot be violative of fundamental rights. The law cannot be violative of the basic structure of the constitution. So our fundamental rights is the basic theme of our constitution. So I think, this is my personal opinion, that the Second World War is a turning point of the human civilization. After Second World War, it was realized by the human community that only the war cannot solve the problems. As because at that time, during the time of the imperialism, only the pleasure of the rulers was to dominate the other country, to conquer the other countries. So now you see the war, although war is going on, but war can also be solved by dialogues. It is now discouraged, as because the war cannot solve the problem. Second World War says that war cannot solve the problems. So what is the mechanism to solve the problems of the human community? The mechanism of this to solve the problems of the human community is that we are to establish the human rights. So the one fruits after Second World War, one mechanism was evolved, that is the Universal Declaration of Human Rights. The, our Constitution, what I want to say, that our Constitution is a reflection of the Universal Declaration of Human Rights. Our Constitution is a reflection of Universal Declaration of Human Rights. So the Article 12 to 35, these are all provisions of the Constitution. So in the definition of law, as I've said, the definition of law that the legislature have the rights to make the law, to enact the laws, but that law should not be inconsistent. That law should not be violative of the fundamental rights, and that power has been given to the Supreme Court. So if it is any provision of any legislation or any provision, and that is why it is said that your judicial review is the basic feature of our constitution. Versus so our constitution, the judiciary is judiciary is known as the centennial of the democracy. Judiciary is known as the guardian of the constitution. So any law found by the judiciary, say for example, say TADA. The TADA was enacted to curb the terrorism. Okay, TADA was enacted to curb the terrorism, and when it was found by the National Human Rights Commission that it is violative of human rights, then after recommendation of the National Human Rights Commission, then it was repealed by the Supreme Court. So Supreme Court is empowered if it is found that there is violative of any fundamental rights of the Constitution, then that law can be repealed by the Supreme Court. So come to the main point that we must ensure the citizen that determination. You see, when you are going to the field, when you are going for whatever the reason for public utility or other regions, as because we need that we have some common needs, some general needs, some we varieties needs are there we have. So to fulfill our needs, definitely, as I have said, the sense of improvement, definitely conflict always arises. But question is that conflict should be amicably resolved. That determination should be impartial determination. By whom? By the officials. So the citizens should be ensured. They should be ensured for impartial determination of the dispute by the officials. Third thing is the citizens must be protected from unauthorized encroachment. You see, unauthorized encroachment, being the citizen, you have some fundamental rights. Every person, from president to PM, they have their own power, they have their own duty. So they are to act according to within their limits, within their boundary. Even in a football match, there is a system, there is a boundary. Within the boundary, within the territory, they are to play. Even in a drama, whatever you do. So in football, right out to play the right side, left out to play the left side, forward to play on the forward side, goalkeeper to keep the goal. So similarly, our officials, they have some powers. Since they have some powers, they have some duty, and they have some accountability, liability. So there should not be any unauthorized encroachment. You see, one famous case is there, Cochrane versus Indonesia. Cochrane, probably versus Indonesia. Cochrane was a dacoit. Cochrane was dacoit at midnight. He was disturbed by the police official, that too at midnight. Then one case was filed. That is the violative of fundamental rights. He may be a convicted person. He may be a convicted person, but he has also right to prevail his fundamental rights. The court said he may be a convicted person, he may be a dacoit, but police cannot disturb him, that too at midnight, without having a reason. Understand? So we must protect our citizens from unauthorized encroachment. There should not be unauthorized encroachment. Yes, if the police have some warrant or police have some authority, then the police can go at any time. But without having any authority, nobody can encroach. No administrative officer, no administrative power can encroach to the liberty of the people, the liberty of the citizen. The fourth thing is, who exercises the public power? He may be chief minister, he may be prime minister, he may be deputy commissioner, whoever, accountable to the people. They are always accountable to the people. See, and that is why we have right. We have right to criticize the prime minister, act of the prime minister. We have right to criticize any officers holding the public power. So these are the basic things. These are the basic features of the administrative law. Okay. So the concept of the administrative law, it's increasingly developed to control the abuse, as I have said, control the abuse and misuse of the governmental powers, and to keep the executives and its machineries within the limits of the powers. So you see the rule of law. Suppose The rule of law is a golden thread through every provision of our Constitution, and it is said in several cases. It is said it's the basic piece of our Constitution. This rule of law, it was propounded by A.B. Dicey, A.B. Dicey, the supremacy of law and the equality before law, then predominance of the legal spirit. The rule of law, that means the rule, not rule of man, the rule of person. Suppose I am the principal of my college, so definitely I have some powers. At the same time, I have some duties, but I cannot run my college according to my own whim or according to my own will. I may have my own philosophy. I may have own logic. Personally, I may have some attitude. But as a holder of the chair, as I am holding the chair of the principal, I am to obey. I am to follow the rules and regulation of the college. So that is the rule of law. If I follow the rule of follow the law, if I follow the rules and regulation of the college, by following the rules and regulation, I am conducting the college. Then that is the rule of law, not rule of person. So what the law says, we have to follow the law what it says. What is the law? What is the law? The Constitution is the law of the land. This is a very interesting story that once in UP Assembly, one reporter, he wanted to distribute some pamphlets, and in a house, the speaker is the guardian. The speaker is the authority. So whatever you do, it must be within the permission. It must be permissible and it must be authorized by the speaker. So you wanted to take permission from the speaker to distribute the pamphlets in the house, but in India, normally the speakers are from the ruling party. So obviously sometimes he must be biased. But in American Constitution, in America, the speaker is always neutral. This is the difference between the speaker, the position of the speaker in India and America. So what happened? Then it was not permitted. It was not permitted. It was not permitted. Then, but ignoring your order of the speaker, ignoring the order of the speaker, the reporter, he had distributed the pamphlets. Okay. Then the speaker asked him to arrest. He asked the marshal to arrest him, and somehow he managed to fly away from the house and took the anticipated bail from the court. And being agreed with the decision of the court, the speaker sent one letter to the court that you should not encroach in my area, in my subject. Then ultimately, just a minute. Ultimately, matter sent to the Supreme Court, and Supreme Court unable to solve the problem. Then it was forwarded to the president. The question arises that who is supreme? Who is supreme? The legislature is supreme, the executive is supreme, or the judiciary is supreme? Legislature says that we are the lawmaking authority, so we are supreme. Executive say you may make the law, you may enact the law, but we implement that law, so we are supreme. You know, the Supreme President of India is the supreme authority of the executive. And judiciary says, no, we are the guardian of the Constitution. We are interpreter of the Constitution, and we are the decision-making authority. If there is any dispute or conflict, only we can decide it. So we are supreme. So again, the President of India, he sent back it to the Supreme Court by Article 143 advisory jurisdiction. Then ultimately it was said nobody is supreme. Nobody is supreme, neither legislature nor executive, even the judiciary. The who is the supreme? The Constitution is the supreme. The same thing was reiterated in the case of T.N. Sessions case. So the who is supreme? The law is the supreme. That is the rule of law. That is the reflection of rule of law. The law is the supreme authority. The Constitution is the supreme authority. You know, the Constitution, all the legislation, they are to follow the provision of the Constitution. It must not be inconsistent with the provision of the Constitution, whatever law you make. But the provision of one legislation must not be inconsistent with the provision of other legislation. So there must be one consistency. There must be some consistency. So the rule of law in Eddie Jabbalpur case, in Kesavananda Bharati's case, there are so many cases, that it is said that rule of law is the basic feature of our Constitution. Second thing, the natural justice, the principle of natural justice. The principle of natural justice, fair hearing. The first principle is audio alternate partem. Fair hearing. No man should be condemned unheard. Audio alternate partem. Second is no man should be made judge for his own cause. Third thing is every decision must be supported by reasons. So audio alternate partem, do you know when it was first applied? It was first applied by God. And when Adam was asked to go to the Eden Garden. The Eden Garden means the art, with some assignment. And Adam said that, no, I cannot go alone. I need one partner. I need one friend. Then Eve was made. Eve was made with clay. And then both Adam and Eve was sent to Eden Garden, that means to the arts, with some assignment. But one condition was given by the God, that you cannot take anything there in the Eden Garden. This is the condition. This is the precondition. You cannot take anything in the Eden Garden. So after reaching the Eden Garden, it was found that the whole Eden Garden was full of flower and fruits. Full of flower and fruits. So temptation started. Eve wanted to take the fruits. Then she asks Adam that, you see, is so beautiful flowers and fruits. Here, nobody is here to see us, so we should take the fruits. Adam said, no. God says you cannot take the fruits. Don't take. But Eve, being tempted with the ripe fruits, she took one fruit. And after taking fruits, she pursued Adam to take the fruits. That's because he has already taken the fruits. And by applying the most emotional word, please, you take now, please take. That's because she has already taken the fruits, and she wanted that Adam should also take the fruits. And ultimately, we already honored the request of the girls, and both Adam and Eve, they took the fruits. And after returning to the heaven, God asked them, in spite of my direction, why you have taken the fruits in the Eden garden? So this is the implementation of the first principle of natural justice by God. It is not my say, of course. It is said, it is very nicely written in the IP message, the book of administrative law. So it was firstly applied by the gods, the first principle of the natural justice. No man should be condemned unheard. That means fair hearing. You must give the opportunity to the other person. Suppose you are a government official, one of your official, one of your staff, he or she is absent for 1 month without giving any notice, without giving any prior information to you. You cannot dismiss the your subordinate staff, your officer, whatever, your officials, without giving him or her any notice. You cannot give you must give him or you must give her to defend himself. The opportunity must be given to him. In the famous Maneka Gandhi's case, in Maneka Gandhi's case, the Maneka Gandhi's passport was impounded in Bombay airports. At that time, Indira Gandhi was the Prime Minister of India, and there's a in between Indira Gandhi and Maneka Gandhi, there were no good relation, a tutu-meme relation. So the passport of Maneka Gandhi was impounded in Bombay Airport, and later on, court says it's a violative of Article 14, violative of Article 21, and violative of natural justice. As because before impounding her passport, the opportunity must be given to her. The opportunity was not given to Maneka Gandhi. So this is called arbitrariness. This is arbitrariness. This is encroachment. This is encroachment to the rights of the citizens. So the natural justice, the first principle, no man should be condemned unheard. You must hear. Your peon is absent for 2 months. You must hear why he or she is absent for 2 months without giving any notice, without giving any information. You must give him or her a notice to defend himself. So this is called the fair hearing, principle of fair hearing. The second thing is no man should be condemned, no man should be made just for his own cause. Nemo jude sua causa. No man should be made just for his own cause. In Kripa's case, in Mahapatra case, in Kripa case, he was this acting chief conservator of the forest in Kujambu in Kashmir, and on the other hand, in one hand, he was applicant for the post, and other hand, he was also member of the selection committee. So he has the interest. When there is a match in between India and Pakistan, the umpire is also appointed by either Australia or from New Zealand or from any other countries outside of India and Pakistan. That's because there's a possibility, there's a possibility or likelihood of biasness. Rule against bias. And third thing is, every decision must be supported by reasons. A reason must be there. The obiter dictum must be there. Reci decidendi must be there. So the principle of your natural justice in running the government, of course, there's a basic thing. There's an entity of the government. You cannot say who is government. You cannot say no. The President Kovind is the government. You cannot say President, your Prime Minister Modi is the government. You cannot say the Chief Minister Dr. Himanta Biswa is the government. No. Government has its own entity, but what is the what is the government? And the government is what? That government has different various departments. What is Cochrane Law College? Cochrane Law College is a legal person. Okay. What is the result of the Cochrane Law College? The result of all semester, when the results of all semester are good, then you can say that result of Cochrane Law College is good. When you can say the students of Cochrane Law College is good, when all students are equally good, then you can say the students of Cochrane Law College is good. So similarly, the government may have its own entity, but the government is consisting of different departments: education department, health departments, irrigation departments. Various departments are there, and these departments must act properly. How? What is the meaning of properly? They are to follow the rules of administrative law. These governments, all the departments, they have some officials. Say Judicial, earlier ASCB. Earlier it was said ASCB means Amar service ekebare beya. So now it is not that. Now it is good. Judicial now. So Judicial, in Judicial, say Guwahati University, suppose. It will be easier for you. Vice Chancellor is, post of the Vice Chancellor is there. Post of Registrar is there. Some professors are there. And some other officials are there. So how to appoint a Vice Chancellor? How to appoint the Registrar? As I had already said, how to appoint your driver in your omnibus? The driver must have the driving license. So any person without having any requisite qualification, we cannot appoint him as a Vice Chancellor. Similarly, the engineering department, PW department. The PW department, there are so many posts. From chief engineer, commissioner, chief engineer to junior engineer, there are so many officials. And they have their own power, they have their own duty. So when to appoint and when to dismiss, when to appoint and when to dismiss, how to conduct. You see, earlier, as I told you, that during the time of the police state, that the purpose of the law to control the society. Now the purpose of the law is not to conduct the society, but to develop the society. You mind it. You keep it in your mind. Now law is to develop the society. Say for example, Food Security Act. Food Security Act not to control the society, food security to develop the society, food security to help the marginalized people, marginalized section. So this is the evolution of law. This is you see, law is a very dynamic term. It is not a static term. It grows with the development of the society. You see, due to growth of the development of the society means the growth of the development of the society means indirectly depends upon the growth of the science and technology. Due to growth of the science and technology, the society is growing up. And law is going with the hand to hand with the society. It is to catering the changing needs of the time. You see, the 60, 70 years, even 50 years back, we didn't have this computer system. Earlier we didn't have the mobile phone. Now we have the mobile phone. Now we have this, what is called artificial intelligence. Now, so we have cybercrime. So we have the cybercrime. So this is the needs of the time to enact one cyber law. Of course, we have Information Technology Act 2020. We have, Information Technology Act 2000, 2002 probably. I may be wrong. So now it is a need of the time that what that one side we need one cyber law. Okay. Similarly, two you see two types of laws are there. One a priori or a post priori. Some laws are made earlier, say Constitution made first, then it is applied. Say income tax law made first, then it is applied. But other laws after observing of the facts of the society, after observing of the facts of the society, law is meant. Say now we need witch hunting, anti-witch hunting law. We had anti uh, mm, uh, anti-terrorist law. Why? Earlier there was no terrorism. Now we have to stop the terrorism. We need the law. So after observation of the facts of the society, the legislature enacts the law. Okay. So so the all the governments, their how they will run properly, how they will conduct, how they will fulfill the needs of the citizens, so that that branch of the government, the department of the government must run properly. How they can run properly? They can run properly by following the principle of natural justice. They have to follow the natural justice. Sorry, they have to follow the principle of the not only the natural justice, all the principles of the rules of law. So the constitution, in one hand, is a good constitution, but so for the administrative law is concerned, it is in motion. Constitution, we may have good constitution, but if it is not in motion, and if to fulfill the goal of the constitution, to fulfill the objectives of the constitution, then it is imperative to follow the principles of administrative law. Say, as I have said, the judicial review. Judicial review is the basic feature, one of the basic feature of our constitution. The judicial review. What is judicial review? So we have the legislature to the lawmaking authority, the executive, the law executing authority, the judiciary is the decision-making authority. So after making the law, if you study the Kyoto Halon case, in that case it is said that a judicial review is the basic feature of the Constitution. In anti-defection law, there, para 6, in para 6 it was given, I have already said that your speaker is the guardian of the Constitution, is the guardian of the House, is the authority of the House. So in para 6 of the Anti-Defection Act, it is said that whatever decided by the speaker, it will be final. And it was challenged. It was challenged. As because deciding authority is the judiciary. Only judiciary can decide. The legislature cannot decide. Okay, of course, sometimes legislature decides, sometimes executive also decides. Say, you see, doctor. When a doctor give you the fit certificate, he is performing a quasi-judicial function. He's a doctor. He's not part of the judiciary. But this is decision making. He has decided that you are fit. So the fit certificate of a doctor, it's a quasi-judicial function. So we have the quasi system. Quasi means seemingly. So there, the speaker, he may be a speaker, he may be authority of the House, but his decision may not be final. So it was deleted. It was removed by the judiciary, by the Supreme Court. The para 6. How? By applying the doctrine of severability. If any part of a legislation, if it is found that that part is not required, and that part is violative of the fundamental rights, then it can be severe. It can be separated by the judiciary. So similarly, apart from all these principles, the principle of ultra vires, the principle of separation of powers, the principle of your natural justice, judicial review, rule of law, we have, apart from all these things, all these principles, the we have the provision of public interest litigation (PIL). For the interest of the public, you can file PIL in the High Court or the Supreme Court. Ombudsman is there. The Central Vigilance Commission is there. Our provision of RTA is there. You have the right to know the facts of the government activities, except if it is not related to the sovereignty of the government, if it is not related to the security of the government. So there is a difference between secrecy and confidential. So through RTI, in a department, what is going on, you can know everything. By paying what rupees 10, you can know, you can able to know, you can know everything about the details of the office, about the details of the data, about the details of the figures. So all these things, of course, I must say that Lokpal has not been passed yet. For your kind information, I am telling you, it was initiated. Do you know it was initiated in 1967 by MC Sagla? From 1967 till now, several attempts took place in the House, in the Parliament, to pass the Lokpal. And you know, the Anna Hazare and his party, they fought a lot to enact the Lokpal, but it has not been passed yet. It's a debatable question, as because why the government, why any government, BJP, Congress, Janata, whatever, why they are not keen to pass the local bill? The thing is the corruption. The corruption, you know, now corruption is everywhere. And if it is passed local, then you can laws complain even against the Prime Minister. What was drafted earlier. Of course, the president is it's an immune post. It is not. It will not be within the purview of the your local, but other officials, as I told you, because they have their own accountability. Those who are accesses the public power, they are accountable to the people. So since they are accountable to the people, so what they are doing, how they are functioning, whether they are following the rule of law, being the citizen, we have the rights. Definitely, we have the rights. So, however, it hasn't. In your time, I think we are very hopeful to the new generation that in your time, definitely it will be passed. So the importance of the what I want to say, the importance of the administrative law, day by day, it is developing. And why it is development is because we need the growth. We need the growth with liberty. Imagine, we need the growth with liberty. And now question is, what is liberty? And it is said that when there is no liberty, there is no development. When there is no development, there is no peace. What is the goal of our constitution? What is the goal of all the isms? What is the goal of all the religions? What is the goal of all philosophies? To attain the peace, to attain the harmony, to attain the virtue. So if we want to attain the goal of peace, goal of virtue, goal of harmony, then liberty must be there. If there is no liberty, there will be no development. And if there is no development, there is no peace. So my dear friends, so the maintenance of just social order, the maintenance of just social order to develop a global dimension. Yes, I must say about the your global administrative law. Now we are very much concerned about the global administrative law. And before that, I want to say, I want to ventilate one thing. We very frequently utter about the good governance. What is good governance? Good governance. In good governance, suppose the Chief Minister of Assam, suppose the Vice Chancellor of Guwahati University, suppose the Chief Engineer of FPDCL, or Chief Engineer of PWD, every norms of the administrative laws are being followed. The democratic norms are followed. Transparency is also followed. But if there is no development, then you cannot say it is good governance. So without development, you cannot say good governance. You must develop. That's because the society is the nature of the society, hopes and aspiration of the society, day by day is growing up. You see now, as I have already said, that always the power is there, power from the part of the government, power of the government and the liberty of the people. Always there is a tug of war in between the power of the government and the liberty of people. And if it cannot be solved with social order, then it will create chaos in the society. Now, what is going on in our society now? So it will create chaos in the society. So ultimately, everything, it has its own tolerance. Even a rubber, if you pull it, then one time it will be crushed. So tolerance, within the tolerance, you have to do everything. If within the tolerance, you have to develop. Within the limitation, you have to develop. Within your power, limited power, you have to develop. So how to develop? With good governance, which grow with liberty. And now you see that the global, I want to conclude my speech by saying the global administrative law. The domestic, it was domestic, very narrow domestic. Now it has been transformed to the open global mechanism for global governance, as because the market become one market, global market. And now we are going to reshaping the new ideologies, new norms, new boundaries between the domestic and international affairs. And globalization signifies two things. One, somebody says that globalization is for the world is a huge market. You see, now everything is contractual. Our life becomes contractual. Everything is contractual. So even even you have heard about surrogacy. Although it is not, it is against the public order. It is not covered by the Indian Contract Act, but it's a contract. And our everyday life becomes contract. If you ask your friend that please do one thing for me, what will do in return? Even if you ask your kid, they go for a study, then definitely he or she will say that what will give me if I go for a study? Everything is contextual. So in one side, the whole world becomes a huge market. And another side, in humanitarian side, the world is going to be a big family. This COVID-19 scenario, I think it's a turning point of human civilization. So this COVID-19, it is said that there is no boundary. COVID-19, it has no choice that he is old, he's young, that he's black, he's white, he's male, female, he is Hindu, he is Muslim. No. It affects severely the whole human community. Unexpected, unbelievable. So now we become a family, world big family. So once Plato said there will be no boundary in the world, in the territories. There will be no territories in between the countries. I hope that one day there will be no territory amongst the countries. So the competition is going on, of course. The competition should not be, of course, it's a free competition, but it should be fair competition. At the same time, it should be fair competition. Uh, the individualism and the individualism and the interdependence. We are interdependent to each other. It must go together. Similarly, the Constitution must go with the principle of administrative law. So, the relevancy of the administrative law in terms of the provision of the Constitution is imperative. Without following the principle of administrative law, we cannot fulfill the goal of the Constitution. As I have said, we cannot fulfill the dream of Mahatma Gandhi, that Ram Rajya. That means Ram Rajya means a Rajya of rule of law, dharma, and you see, day by day, society is, of course, it is growing up in different aspects. On the other hand, we are deteriorating, and I am very much hopeful that the new generation, since you are the captain of the society, you have chosen the very dignified profession, the legal profession. You see, it's from Abraham Lincoln to Mahatma Gandhi, up to Kovin, all are advocates, all are lawyers. We, the lawyers, we are the captain of the society. We are to lead the society. So it is said as a noble profession. It's said as a very dignified profession. Of course, it's a dignified profession. So you are to maintain the dignity of this profession. You have to maintain your own position, your own status. People must know that you are a law student. So and another thing I want to say that to be a good lawyer, you must know the facts, all the facts of the society. So go through the newspaper regularly. You keep contact with the society always, as because you must know the facts of the society. Unless you don't know the facts of the society, you cannot solve the problems. Today or tomorrow you will be jurist. Today or tomorrow you are going to be a judge. Today or tomorrow you are going to be a prime minister, chief minister. You can join in the politics. So you are the leaders. You are the captain of the society. With this dignified profession, be proud of this profession. I'm always proud of my profession. So with this, Cochrane Law College is very Professor Aditya is very close to me. Now your ma'am, she's also a very sincere principal, and I'm very much thankful to all the organizing, including the organizing committee of this webinar. With my heartiest gratitude to the principals and the members of the governing body, Professor Aditya and other faculty members, esteemed faculty members, and my dear friends, students. I'm very much thankful to you all that you have given me a very good opportunity, proud opportunity to deliver this lecture in the fond memory of late Niranjan Narjari. It's a very good venture. Yesterday I talked to your principal. Very, very good venture, and I hope the Cochrane Law College one day it will lead the legal education not in Assam, in entire Northeast region. With this, I conclude my speech. Thank you. Thank you very much.
Uh, Thank you, sir. But sir, we have some questions, queries in the
Yes.
chat
Okay.
box.
Please, please.
So, where is the head office of Lokpal in our state of in our state? It means Assam. And how can we appoint the Lokpal in the state? Is there Lokpal system in our state, sir? The question
No,
is from.
as I have said, the Lokpal bill has not been passed yet in India. Okay. Of course, look, in some states, Lokayukta is there, but without teeth, I must say, without teeth, without power. See, even RTI, if you say about the RTI, actually we have here commissioner, we have a full-fledged office, but they can make some inquiry. They have some limitation. Though in papers, so many powers is given, but in letter in spirit, what is called, no power is given. Similarly, and so we sometimes we witness some misuse of RTI Act. So Lokayukta in India, in Assam, since Lokpal bill has not been passed, Lokayukta, I'm not sure about it. Probably we don't have the Lokayukta. In some states of India, there are Lokayukta. Okay.
Oh, okay, thank you, sir. Our next question is how the administrative law is relevant in present context.
Administrative law is relevant in present context. First of all, we are to stop the corruption. Basic thing. Any kind of corruption. So to stop the corruption means it is not only the financial corruption, the other corruption, political corruption, social corruption, financial corruption, any kind of corruption, academic corruption even. So now you see that sometimes you'll observe that one person, he or she doesn't have the qualification, proper qualification to appoint for the post. But as one minister is in favor of him or her, he's appointed. By the end of the favor of the minister, one minister, he or she is appointed. It should not be so. It should not be so. We should follow the rules of the administrative law. The advertisement should be given. Selection committee should be formed, and the criteria for selection should be made. Then the written exam or whatever is formed by the selection committee. These things should be followed. Then you can appoint. Then you can appoint, but without having any qualification, that means that is the violation of natural law. That is the bias, rule against bias. You should not be biased. So in present situation, it may be rule of law, it may be the natural justice, it may be rule of ultra vires, it may be whatever. But unless the principle of natural law is not followed, then all the government officials, all the government functions, all the government departments cannot run properly. If the departments are not run properly by following the rules of administrative law, then that government cannot run properly. Then there will be no good governance. So I want to say that the principle of administrative law in present time, it is imperative to follow the principle of administrative law. Okay.
Thank you, sir. So participant, if you have any queries, then you can directly interact with sir also. I think there is no queries, sir. No more queries in the chat box also. So thank you, sir, for enlightening us and also sharing your valuable thoughts and experience pertaining to the topic. And I hope it will be highly beneficial for all of us. Thank you so much. Thank you so much for joining us, sir. Now I would
Thank
like
you.
to request our principal, Madam Ms. Prita Brahma, to deliver the vote of thanks.
Okay, before
Basic.
that, I want to say, before
Yes, sir.
that, Duhita,
Yes.
before that, I want to say one thing. And now onwards, may I take myself as a family member of Cochrane Law College?
Yes, of course, sir. Of course. We hope to see you again, sir. Thank you so much for
Okay.
joining us, sir.
Thank you. Thank you.
So over to you, Prita ma'am.
Yes, thank you, Duita. Thank you so much, sir, for your deliberation on the topic relevancy of administrative law in terms of objectives of the Constitution. Uh, our guest speaker have first started uh, say by giving a brief introduction of the features of the Indian Constitution and these features from which constitution was it borrowed and implemented in the Indian Constitution. He has highlighted uh, that particular aspect in the beginning, and then he went on to saying that to prevent the misuse of the powers, there shall be check and balance, so that there is an impartial deliberation of justice and the rule and order. And also, he had highlighted that among the three organs of the government, that is legislative, executive, and judiciary, none of them are supreme, but the supreme that we can call it in India is the Indian Constitution is the supreme, and which is above all the organs of the government. And also he has highlighted the principles of natural justice, and when it comes to fair hearing, he had given an example of Adam and Eve, and he said that it was God who had first introduced this concept. And then also said he shared his opinion that uh, uh, when it comes to growth and development, liberty should be there, and if there is no liberty, then it is not possible to obtain the peace, goal, and harmony in the society. And in order to maintain the just social order in the society, there should be a development in administrative law. And he had also related the present scenario with that of the need of administrative law. That means the present scenario of COVID-19 pandemic, he had related with that of the administrative law and how important it is, uh, and how important it is for the development of administrative law to maintain peace and harmony in the society. And also I thank you, sir, for taking the questions of the participants, and I hope that the participants are also enlightened by your deliberation, and I'm sure that they are enlightened, as we can see certain questions at least, there is a I could see the connection between the speaker, the guest speaker, and the students. So, which is why there we could see certain questions as well. So, I'm sure the students are also delighted, and thank you, Bhuban Barooah, sir. Uh, Seeing you after many years, I saw you last in the Tejpur Law College when we had gone for the conference,
Yes.
and after that I did not have the opportunity to see you, but then we are in touch when it comes to certain uh, matters of Guwahati University. So thank you for giving us your time, sir.
Thank you. Thank you. Thank you. It's my pleasure. It's my great pleasure.
Yes. Okay, sir. I think then we can conclude. So we hope to see you
Okay.
again.
Sure. Sure. May I leave? May I leave
Yes,
now?
sir. Yes, yes.
Yes, sir. Thank you.
Thank you.
Thank you, everyone, for
Thank you.
joining us.
Thank you. Thank you. Thank you.